Hello folks, welcome to the Edupedia world, and I am Abhinay Gupta. Today again we'll continue with the topic, the meetings of the board and its power, right? So we'll discuss about the meetings that the board is going to conduct, how will the meeting be conducted, what is the quorum, how is the notice being sent, who are the directors who are supposed to attend the meeting, who are the directors who cannot vote, right? And what do we do in case of a tie? These kind of a situation, right? We'll be covering meeting of other audit committees, then remuneration committee and stuff, right? So these are the various kind of topics that we'll be covering in this chapter, right? So by the name you understand that we'll be understanding in detail the meetings of the board, right? And all the powers that the board of directors hold in a company. In the previous lecture, we have covered the introduction part, and we have also covered in detail section 173, right? All the 5 subsections, subsection 1, 2, 3, 4 and 5 have been covered in detail already in the previous lecture. If you have missed it, please go back and go through that lecture, because that is what creates a base for the chapter, right? And as we have already seen, we would be covering section 173 to section 195 in the entire chapter, right? And we'll be heading forward to each section in serial order. So as we have covered section 173 in the previous chapter, today we'll be covering the questions that have been asked in your previous examinations based on section 173, right? So before getting to the questions, I'll just show you a glimpse. We have a lot of questions that have been asked in the previous examinations, right? But before jumping on to the questions, today what we are going to do is, first, we will briefly touch through the entire section 173, right? So that you get a recap of what we have studied in the previous lecture. And that will help you in understanding and solving the questions better, right? So what have we seen in section 173? Let's have a revision of it and a quick recap, right? So section 173, subsection 1 and subsection 5, both of them, they dealt with the minimum number of board meetings, right? Or actually the number of board meetings that have to be conducted in a year. That is the minimum requirement, right? So what we have seen is that the first board meeting that should be conducted within 30 days of incorporation of the company, right? And you need to have a minimum of 4 board meetings every year. And the intervening period between 2 board meetings should be a maximum of 120 days and nothing more than that, right? If you do not hold if the gap between the 2 board meetings is more than 120 days, you would be deemed to have contravened the provisions of section 173, right? Then we had also seen that the central government, they may have the power to either exempt or modify the provision of section 173 subsection 1 for any class of company, right? And in section 73 subsection 5, here we see the same provisions, but for the other companies like a one-person company, small company or dormant company, right? For these type of companies, again, section 173 subsection 5 also prescribes the minimum number of board meetings, but that is not equivalent to 4. For them, 2 board meetings in a year would suffice the requirement of the provision, right? So 2 board meetings, but over here they say that you will have to have at least 1 board meeting in each half of the year, and the gap between 2 board meetings should be more than 90 days. Over there we had seen the gap should be a maximum of 120 days, but over here we see that the gap should be more than 90 days, right? And the thing that I did not discuss with you in the previous lecture was the comparison with the old act. So as per the old act, that is the 1956 act, you had to hold at least 1 board meeting in every quarter of the year, right? But we have no such provisions in the Companies Act 2013. What Companies Act 2013 has to say is that you will have to hold 4 board meetings in a year, right? That is the minimum requirement, and the maximum gap is of 120 days. There is no requirement, nowhere does the act say that you will have to hold 1 meeting every quarter, right? So if there is a question, do not get confused, but also read the provisions of the question, whether it is asking you to answer the question as per Companies Act 2013 or 1956. But chances are very rare that you will get a question based on Companies Act 1956, right? So next we had a section 173 subsection 2, electronic mode and video conferencing, right? So here we saw that a director can be present in the meeting, can discuss the agenda of the meeting, and can vote for or against the motion or the resolution in a meeting, either in personal capacity, either he's physically present, or via a video conferencing or any other audio visual mode, right? But the audio visual mode that we are talking about should be capable of recognizing the director. The director should be recognized, right? And it should also be capable of recording the meeting and storing it with the date and time. And CG does exempt certain matters from video conferencing, etc. by notification in the official gazette. So as per the central government, there are certain matters that cannot be discussed over a video conference, right? For those matters, the directors will have to be physically present in the meeting, right? Then we have section 173 subsection 3 and subsection 4, which deals with the notice of the board meeting. So we know that the notice should be sent at least 7 days before the meeting, right? That is 7 days is the minimum period between the notice and the actual meeting, right? And that notice had to be given to the directors at the registered address. Now when we talk about registered address, it is not the actual residential address of the director. It is not necessarily that. The registered address is the address that the director has got it registered in the registry or in the records of the company for these communications, for the communication of notice and other documents, right? And that may be in India or outside India. So do not be confused if you have been given a question in the examination that the director stays abroad and so will the notice be sent. Yes, the notice will be sent, right? And we know that the notice has to be a written notice. It cannot be an oral notice or a telephonic conversation, right? And this notice has to be either delivered by hand, by post, or via an email. Now 7 days does not mean that in any circumstance you will have to give a notice 7 days prior to the meeting. No, there may be certain urgent situations, urgent transactions that have to be discussed and you don't have time for that. So you could give a shorter notice, right? But for that there is a condition that if you are giving a shorter notice, at least one independent director should attend the meeting. That is so that the directors do not unnecessarily create a situation where they could just give a shorter notice. Okay, we'll have to have a notice 2 days hence, the day after tomorrow, right? And then only 2-3 directors who actually wanted to pass this resolution, they attend the meeting and they pass the resolution, and others are not able to attend. That can be a situation, right? So they say that even if you do something like that, at least one independent director whose decision is not biased will have to attend the meeting, right? Otherwise, the decision which will be taken in the meeting would be circulated to all the directors, and then at least one independent director should ratify the meeting, ratify the conclusion of the meeting, the result, the decision. And section 173 subsection 4 actually defines the penalty if you contravene any of the provisions of section 173, and the penalty would be an amount of rupees 25,000 for each director in default, right? So those were the provisions of section 173 in brief that we have discussed, and now we move on to the questions, right? So if you look at the screen, we have too much of questions. That doesn't mean that the questions have been appearing in many attempts, but definitely the questions have touched almost all the topic of this section, right? Okay, if you look at the screen, you may see that the questions appeared in 1999, 2003, but yeah, you had a question in 2013 as well, and that was an 8-mark question, right? So an 8-mark question from one particular section that can be very critical for your examination. So you have to understand this section in detail, right? So now we'll see what are the various kind of questions that the institute did put forward in the previous examination, and what are the other kinds of questions that could be asked from this section, right? So let's take an example. A question can be asked to you that had been actually asked in CS examinations also. You know that the law topics, the syllabus for law is very similar to our CA law curriculum, right? So in CS, from this section, you had been asked a question where you had given a situation, you had given the dates of 4 board meetings, right? One in January, the other in May, the other in October, and third in December. And then you were asked whether or not the provisions of section 173 have been fulfilled? The answer was no, because if you look into the question, the gap between May and October, right, the 2 months, was more than 120 days, and hence the provisions of 173 subsection 1 were not followed, and that was a default, right, and hence the director would bear the penalty of rupees 25,000 each, right. So just look at the way the questions are put forward. You are given 4 dates, and then if you think, okay, 4 board meetings are held, that was the minimum requirement, I guess. There was no requirement for every quarter, so yes, it is correct. But no, right? You have to check all the provisions, and one provision, that is 120 days, the minimum gap, or sorry, the maximum gap of 120 days was not fulfilled. Now, the other kind of question on section 173 subsection 1 could also be that you are given a date for 4 board meetings, right? And there were 4 board meetings held, and the gap was all less than 120 days. But in that situation, if you see, there was one board meeting that was held on somewhere around after the 3rd board meeting. The 4th board meeting was held after, suppose, 115 days, right? So that was just 5 days before the deadline, and that meeting was adjourned due to want of quorum or something. So the adjourned general meeting was held beyond your deadline, beyond 120 days. So will that be a contravention of this provision of section 173 subsection 1? The answer is no, because the adjourned general meeting is actually considered to be a mere continuation of the original general meeting that was supposed to be held. Board meeting that was supposed to be held. I'm sorry if I spoke general meeting anywhere. It is the board meeting, right? We are talking about board meeting only. We are not talking about general meeting anywhere over here. So in that situation, this can be another trick given to you in your examination. So please keep in mind, the adjourned general meeting is a mere continuation of the adjourned directors meeting is the mere continuation of the original directors meeting, board meeting, right? So the provisions of section 173 will not be deemed to be contravened, right? And so the provisions have been fulfilled, and that is valid. But there could be other question also where you are focusing on this, and then you realize that you had held just 3 board meetings, and 4th was the adjourned meeting. Like 2 earlier, 1 meeting that was adjourned, and then the 4th meeting, which is the adjourned meeting. So that is not the case where 4 meetings are held. It's only 3 meetings, because again the adjourned board meeting is the continuation of the original board meeting. That is considered to be 1. That is not considered to be 2 meetings. Now, one more case could be that you had held, suppose, 1 board meeting in January, the other board meeting in February, the other in, suppose, May, and the 3rd one on 28th December, and the 4th board meeting on 28th December, and that was adjourned. And the adjourned general meeting was held in the adjourned board meeting was held in the next calendar year. So now over there, now in this situation, will it be deemed to be a contravention of section 173? The answer is no, because although the adjourned board meeting was held in the next calendar year, it will be considered to be a continuation, and hence the date of holding the board meeting would be considered to be 28th December itself, right? So there is no contravention of this section. So these are the small little tricks that could be put into your question, right, by the institute in your examinations. So far you have not been asked any question on section 173 subsection 2, right? But if you get a question on this, the only kind of questions that you could get is a situation where the board meeting was held and it could not be recorded, right? That could be a situation. Or there could be a situation where the central government had given notification that it had to be held in a physical board meeting. The directors have to be physically present, but then it was held by a video conferencing. So the question could be whether the resolutions passed would sustain, right? Would those be actually applicable? Would those be valid? So the answer is no, right? Because that is not considered to be a valid board meeting. Next, if we look at section 173 subsection 3, right, there you could get a topic, right, like a director, when he was invited for a board meeting, he said he knew that he would not be attending the board meeting, and hence he told the other directors that I won't be attending the board meeting, don't send me a notice for the same, I will anyways not be there, right? So in that situations, the other directors, they do not send him the notice for the board meeting. Now, will that be a contravention of section 173 subsection 3? The answer is yes, right? Because section 173 subsection 3 says only one line, that the notice has to be sent to all the directors. So whether or not a director waives his right to receive the notice for the board meeting, he would be served a notice. That is the responsibility of the board, right? Next question could be that one of the director in the board had been out on a trip, right? He went abroad, and then they had hired another director who is the alternate director now, right? Who is working in the position of the original director who has gone out of the country, and he's not a proxy, he's not a representative. We know he's not a nominee for that director. He's not working according to the original director. He is working independently on his own, right? So when they send out a notice to hold a board meeting, they do not send a notice to the alternate director, right? Now, will that be valid? Instead of an alternate director, they send a notice to the original director. Now, will that be valid? Because they say we know only the original director. He has just come to replace his position for some time. That will be a contravention of section 173 subsection 3, because again the section only says that the notice shall be sent to every director, and since an alternate director is also a director, he is squarely covered in the term every director. We know he is not a proxy, not a representative, he is a director in his own right? So notice has to be served on him, right? And then also the other provisions will also be applicable on him. Like if the alternate director does not attend all the board meeting in the 12th month with or without leave, he would have to vacate his office. Even those provisions will be applicable on him, because an alternate director is always considered to be a director. Although he's an alternate, he's a director, so he will have all the rights and he will have all the duties of a director. Then you could also get a twist, as you could see in your paper in May 2003 and May 1999, right? Over there, what they said, that one director always stayed abroad because he was representing a foreign collaboration. So, my dear friends, just remember one thing: no matter whatever is the case, even if a director is staying abroad all the time due to a foreign collaboration or something, the provisions of this section would apply as it is. So the provisions would apply to the foreign collaborated companies in the same manner as it applies to any other company, right? So again, over there the notice will have to be sent to the director who is abroad, because we know that the notice is supposed to be sent at the registered address. Now that director could have a registered address of a foreign country, and the section nowhere prohibits sending the notice to the foreign company. It says whether the registered address is in India or abroad, you will have to send him the notice over there, right? So he will be sent the notice, and again the period would not be less than 7 days, right? You could also be asked whether a notice is to be served on an interested director. We know that the interested director has nothing to say for the resolution that he is interested in, or for the decisions that he is interested in, and he is not even allowed to vote for such resolutions in the board meeting. So will a notice be important? Will a notice be a compulsion? The answer is yes, because again the interested director is a director, and the act says and the section says that you will have to send a notice to all the directors, right? So there is no exception at all. So just make one thing clear in your mind: if the person is a director, he has to receive a notice. It is the obligation of the board to serve a notice on that director, right? And whenever you get these kind of questions, how do you start your answer? We know that while starting our answer, we have to write the provisions of the act, the provisions of the section. Now, do you write the entire thing? Will you write the entire provision of the section? No. So we could write the statement as under, like, as per section 173 subsection 3, a meeting of the board shall be called by giving not less than 7 days notice in writing to every director at his address registered with the company, and such notice shall be sent by hand delivery or by post or by electronic means. So there is one statement that covers the entire section, right? You have said everything in this section, in this statement, And then you again go ahead and write the other provisions, and then your observation and conclusion, right? So that is how it goes. Now the last point is the non-service of the notice that was asked recently in CA Final May 2003. They had asked you about the consequence of non-service of the notice. If you have not served a notice to any director, what would be the consequence? So your act, your section 173, nowhere defines the consequence, right? So the Companies Act 2013 does not contain any provision for the same, but we would follow the judicial decisions that have been taken. So as per the judicial decisions where it was proved that the notice was improper, like either it was not sent to all the directors, or the mode of notice was not correct, or in any way, if the notice was not proper, then the meeting shall be considered void, right? And the resolutions passed in the meeting should be invalid. And if you want to write a name of a case study in your examination, you could use the case study of Parmeshwari Prasad Gupta versus Union of India, right? And as per that, it will just be void and the resolutions are invalid. But again, the provisions of section 173 subsection 4 would be attracted, and the directors would be liable for a penalty of rupees 25,000 each, right? So that will always be there. That is given in the act. But what will be the condition, or what will be the conclusion of the resolutions is not specified anywhere. So for that, we would refer to the judicial pronouncements. And that is how you will have to write your answer in the examination too. You can not simply write that it is invalid or the meeting is void, right? Because the act nowhere says that. So you will have to write that we are giving these conclusions based on the judicial decisions that have been taken, right? So that is how you answer. So I think that will be all. We have rightly covered most of the questions that could be put forward in your examinations ahead and that have been appeared in the previous examinations. So now that gives us a green signal to move ahead to the next section, that is section 174, right? But we'll take up that section in the next lecture. So up to then, this is Abhinay Gupta signing off. Thank you. Bye-bye.